The Trump administration is currently attacking employment authorization for asylum applicants. This happened the last time Trump was president. They basically extended the 180-day asylum clock to 1 year. And what that means is after you file your asylum application, you can typically become eligible for employment authorization once your application has been pending for 180 days. So you file your application, 6 months later, generally you're eligible for employment authorization, and you can even apply 30 days early after just 150 days. But now that's changing to 365 days, just like happened the first time Trump was president. And simultaneously, there are several other changes that make it almost impossible for some initial employment authorization applicants to even get their work permit. The first one is that if the average processing time for an asylum interview exceeds 180 days, then USCIS can indefinitely pause initial work permit applications. I'll give you an example. Let's say the average processing time for USCIS to make a decision on an affirmative asylum application is 1 year. Historically, it's been much longer than that. I have some people who've been waiting for 12 years for their interview. As long as it's more than 180 days, they can indefinitely pause initial work permit applications. What this means is that most initial work permit applications will just be indefinitely paused. And as an asylum applicant, if you don't already have a work permit, this doesn't impact renewals. Your initial application will never get approved because this pause will just apply indefinitely. Forget about more than 180 days. There are some instances where people have to wait decades for their initial asylum application to be decided. So if the average processing times are higher than 180 days, there's just a pause nationwide on affirmative asylum application initial EADs. There are a couple other changes that go into effect with this proposed new rule that said initial EADs, work permits for asylees, should be approved within 30 days. They've removed that. So now there's no requirement for the government to timely adjudicate your work permit application. It could take way longer if you're even eligible. Luckily, this doesn't affect renewals. At least this proposed rule doesn't, but it's gonna have a big impact on asylum applicants. And the reason behind this is obvious. They want to discourage people from applying for asylum. They want to remove the benefits. They want to use the carrot and the stick. They want to hit you by threatening you with deportation, and they want to remove any incentive to apply for asylum by making it nearly impossible to ever qualify for employment authorization. Before I end this video, I would like to take a moment to read a statement that was issued by the American Immigration Lawyers Association regarding this notice of proposed rulemaking. By the way, guys, this is a proposed rule, so even if it goes into effect, it probably won't be until late 2026 at the earliest. So this doesn't go into effect immediately. If you are an asylum applicant and you're eligible for employment authorization, I urge you to do it now because this will almost certainly go into effect. Anyway, the statement goes, this notice of proposed rulemaking abandons more than 3 decades of policy precedent without adequately addressing the shortcomings that will come with these actions. The Department of Homeland Security has long recognized that individuals should be permitted to work while awaiting adjudication of their pending asylum applications. Today, more than 2.3 million asylum seekers are employed in critical sectors for the American economy, including construction and transportation, industries that continue to face persistent labor shortages. The proposed rule would extend the current 150-day waiting period to 365 days. And DHS would pause initial work permit processing when asylum adjudication processing exceeds 180 days, without rationale support for either policy decision. The proposed rule further estimates it may take between 14 and 173 years to reach the point where initial work permit processing would resume, an extraordinarily imprecise time frame demonstrating both the long-term harm to asylum seekers and the communities they live in, and I would add the economy as a whole. The economic consequences are detrimental to local communities and applicants. DHS estimates asylum seekers could lose between $34.6 billion and $126.6 billion in wages each year due to this action. But this impact expands beyond the asylum seekers themselves to the businesses that employ them, their families, and the communities that rely on their economic contributions. I thought AILA, American Immigration Lawyers Association, put this very well. I mean, right now we're seeing economic issues in our country, so this rule just doesn't make sense. The only reason it would make sense is because it aligns with Stephen Miller's agenda to just make life for asylum seekers in the United States hell. So anyway, guys, I strongly oppose this notice of proposed rulemaking, and I just want to make this video to let you guys know that this is something that will likely go into effect in the near future. Anyway, guys, that's the end of today's video. If you want to stay up to date with all the recent changes to immigration law and policy under the Trump administration, be sure to subscribe. If you or someone you know needs assistance with the family-based immigration matter, I focus on family-based green cards, naturalization, and deportation defense, and I handle these immigration cases nationwide. So if you live in the US and you need assistance or have some questions regarding an immigration matter, the first step would be to schedule a consultation directly with me by clicking the link in the video description below or giving my office a call. Thanks so much for watching, and I'll see you guys next time for another video.